A Nebraska transfer on death deed or Nebraska survivorship warranty deed is used to transfer property upon the death of a grantor. This allows the grantor to keep the property out of the probate process upon his or her death and have it go directly to a named beneficiary. This type of deed can be revoked at any time while the grantor is still alive. In this video, we'll cover the difference between a transfer on death deed and a will, legal requirements for recording a transfer on death deed in Nebraska, and how to revoke a Nebraska transfer on death deed. We're eForms, the world's largest online database of fillable legal forms, and we're here to help you simplify complicated legal matters. To begin creating your own Nebraska transfer on death deed, click the link at the end of this video. Let's start by discussing the differences and similarities between a transfer on death deed and a last will and testament. Both of these documents can help you bequeath real property, say your house or a piece of land, to your child, grandchild, or another descendant. However, there's one big difference. While a will is subject to probate, a transfer on death deed is not. So what is probate? Probate is a legal process during which a deceased individual's debts are paid and assets are distributed. Though this can sound simple, probate can take around 6 to 9 months in Nebraska. There are also probate fees, which are generally 2 or 3% of the estate's value. A transfer on death deed saves your descendants time and money by skipping probate. This means your designated beneficiary will instantly inherit your property when you pass. But how do you complete a Nebraska transfer on death deed? The form itself is pretty straightforward. It will ask for information like your name and your beneficiary's name. However, one confusing section is the legal description. A legal description specifies the parcel's location, boundaries, and physical attributes. This written statement is referenced during title transfers. You can find a legal description of your property on your property tax statements and the current deed. You can also request this information from the Register of Deeds. After completing the transfer on death deed, the next step is to sign it before 2 disinterested witnesses, or people who won't benefit from the property transfer, and get it notarized. Lastly, you'll need to take the deed to be recorded with the Register of Deeds in the county where the property is located. This must happen within 30 days of executing the deed for the deed to be valid. Additionally, the deed must be recorded before your death. Now, what happens if you record the transfer on death deed and later need to revoke it? As the property owner, you can revoke the transfer on death deed at any time before your death. To do so, you have 4 options. Execute, acknowledge, and record a new transfer on death deed, or complete an instrument of revocation that expressly revokes the previous deed, or execute an inter vivos deed, or lastly, sell the property. Of course, death can be hard to think about and talk about. However, by executing a transfer on death deed, you're ensuring that your legacy, what you leave behind in this world, is protected. To get started on your own Nebraska transfer on death deed, click the link below, and be sure to subscribe for more legal content.